So let me ask about what checks exist on the power of the Supreme Court. Are there any self-imposed limits that the court has routinely observed?
First of all, the court is its own guardian. That is to say, it's very concerned about protecting the integrity of the court and its own reputation. It has a great institutional interest in preserving its status as the primary interpreter of the meaning of the Constitution, writing opinions that pass muster with the American public so that it can continue to be taken very seriously and deserving of the respect that the justices believe the court ought to receive. And so toward that end, the court, over the course of its history, has created a number of doctrines which speak to the issue of judicial self-restraint. It imposes its own limits. For example, the court is very reluctant to take up an issue that's not brought before the court. The court is very concerned to answer the very issues raised by the parties and to interpret the Constitution narrowly. If in fact an issue is raised by one of the litigants and there's an option to interpret and resolve the problem by merely looking at a statute rather than going to the constitutional provision, many justices, including Louis Brandeis, believe that the court should not try to reach constitutional questions unless it's necessary to do that. The court has erected other techniques, including the political question doctrine, which the court has invoked, if not consistently. It's invoked on occasion to avoid ruling on issues on the premise that the resolution of those issues are better left to resolution by the political branches, the President and the Congress. The court has said, for example, it will not issue advisory opinions, not a role for the court to do that. And then it's introduced as well a number of other doctrines, technical doctrines, to avoid ruling on particular issues because the issue is not ripe for review, for example, or would be, or the question is moot. So the court has the responsibility more than any other branch to protect the integrity of the judiciary, and justices, very mindful of the place where they work, are very committed to protecting that institution.
Can you discuss the role that presidential appointment plays in influencing decisions of the court?
First and foremost, we recognize that it's a shared power between the President and Senate. It's often overlooked by the American people that it's a shared or a joint power. Presidents often think that it's their power alone, but that's not true. Presidential appointments and the influence on the court has been the subject of great discussion and debate among scholars for many, many years. Some hold that a presidential nominee will be loyal to the president or owes some degree of loyalty, but that doesn't seem to be the case. Studies indicate rather that presidential appointments are often willing to exercise independent judgment. A good example could be seen in the famous Watergate tapes case, United States versus Nixon in 1974, where the Chief Justice of the Supreme Court wrote an opinion for a unanimous court rebuking President Nixon's claim to an absolute executive privilege. So in many ways, the question of the influence of the president on those justices whom he has appointed is very much up in the air. And the reality is that justices who would simply cast a vote reflective of the president's interest, irrespective of the merits in the case, would not be highly respected by members of the bar.
Do you think that the court's power is limited by virtue of the fact that it has to rely on the executive branch to carry out its rulings?
That's a very important issue because historically, some presidents have been well known for dragging their feet, exhibiting disinterest in carrying out or enforcing the Supreme Court's decision. So the court, number one, is mindful of the fact that it cannot enforce its own decision, and that means that the court does rely on the executive, and that is a limiting influence on its power. Going all the way back to Marbury versus Madison, where the court wanted to avoid a head-on collision with President Jefferson, we've known since then that the court has been mindful of exactly the impact of its decisions and whether or not a president might, in fact, refuse to carry out its decision. But here again, justices who refuse to rule on the merits of the case in an appropriate way out of fear that a president might not enforce the decisions is probably not going to be a justice or a court that's going to gain high respect from the American people, and yet we've seen it time and again. So, for example, the court learned an important lesson after Brown versus the Board of Education in 1954, when President Eisenhower was uninterested in enforcing the decision. In the Vietnam War cases in the late 1960s, on 13 separate occasions, the court had the opportunity to rule on the constitutionality of the war, and it passed on that opportunity. Its defenders said the court feared that if it had, in fact, ordered President Nixon, for example, to end the war and bring home the troops, that he might not have complied with the Supreme Court's decision, in which case the authority of the court would plummet, the respect would plummet, or it would plunge the nation into a constitutional crisis in which Congress might have to come to the aid of the court and require the president to enforce the decision or face impeachment. So a lot of imponderables surrounded the court's decision on the Vietnam cases. And so the bottom line here is that we know from Supreme Court papers that occasionally the Supreme Court is very concerned about whether or not its decision will in fact be enforced by the court, but it hasn't, with few exceptions, seemed to deter the court from ruling on the merits as it sees them.
Can the Congress limit the Supreme Court's power?
Congress can as well, through the regulation of the court's appellate jurisdiction, number one. And number two, Congress, of course, does have the authority to impeach Supreme Court justices or federal judges in cases in which the Congress believes that members of the court have in fact committed an impeachable offense. We've only had 17 federal judges who have in fact been impeached by Congress, but we've never yet had a single instance in which the Supreme Court justice has been impeached and removed by Congress. Early on in our history, a Supreme Court Justice Samuel Chase was impeached but not removed in the trial before the Senate. But the very fact that the Congress wields that ultimate power called impeachment reminds everybody of the fact that it does wield great influence over the federal judiciary, even if that power is being used very sparingly.
Does federalism have any effect on the implementation and enforcement of Supreme Court decisions?
Certainly has. On a number of notorious occasions, the Supreme Court has rendered a ruling, for example, in the area of segregation or civil rights discrimination, and then seen recalcitrant Southern governors exhibit an unwillingness to abide by those rulings. Those rulings inspired, in many ways, the opposition by Southern governors and legislators in the 1950s who steadfastly opposed those rulings and refused to enforce them. And that inspired or generated a considerable constitutional crisis in our nation, where ultimately the president was forced to take a stronger hand and carry out the court's rulings to strike down segregation and race discrimination.
What justifications are made for the suggestion that the Constitution should be amended to place term limits on justices?
The justification has been expressed over the course of our history on a number of grounds. One, that as justices age, that they can no longer carry out the demanding duties of being a Supreme Court justice. Number two, more prominently, that when a president has the opportunity to place somebody on the court for a very long period of time, 20, 25, even 30 years, that it's unfair to a nation that changes over time to be hobbled or influenced by a justice appointed to the court by a president that many voters don't even recognize, never had the chance to vote for. And third, simply a function of partisan or political interest, the more often that the court can be subjected to change, the more often it's said that a majority of the country can weigh in and more effectively influence the work of the court.